planning to divide my presentation in 3 parts. In the first part, I will give a general overview of EU's legislative framework, going through main copyright directives and regulations. In the second part, I am planning to provide an overview on modernized copyright rules as a consequence of recent copyright reform. In the last part, I will try to give some examples from the practice of the Court of Justice of the European Union, which gives important interpretation on legal provisions of European copyright directives. If I start with the first part on the general overview of legislative framework in copyright, here it is important to mention that overall goal is to enable copyright protected goods and services to move freely within the EU's internal market. And today, EU's legislative framework, so-called acquis communautaire, consists of 13 directives and 2 regulations, and many of them reflect member states' obligations under international treaties, namely under the Berne Convention, the Rome Convention, also under the TRIPS agreement and WIPO copyright treaties, which were explained very well by Paolo. Also in the last years, the EU has signed other WIPO treaties, the Beijing Treaty and the Marrakesh Treaty, and also free trade agreements, which EU concluded with large number of countries outside Europe, also reflect many provisions in the EU law. And the directives in the EU were adopted with separate blocks, I would say. There are so-called first generation directives, which aimed at specific aspects. So there were specific reaction to the Court of Justice case law, and the result of such harmonization were provisions dealing with specific subject matters without consideration copyright necessarily as a whole. So for example, we have so-called software directive, which harmonizes legal protection of computer programs. It is a very early directive from 2009, and it provides legal provisions on who is the author of a computer program, how it is treated if the computer program is created in the course of employment, what are the economic rights involved, and such things. Another legal act would be related to the satellite and cable directive, also very early from 1993, which aims to facilitate the licensing of copyright and related rights for satellite broadcasting and cable retransmission services. And this directive establishes such key points as, for example, country of origin principle. And according to that country of origin principle, copyright authorizations for satellite broadcasting only need to be obtained for the EU country of origin of the satellite broadcast, and not for the all EU countries where the signals are being received. With respect to that directive, and if we speak about cable retransmission, well, mandatory collective management is foreseen for cable retransmission, and right holders can exercise or prohibit the retransmission of their works only via a collecting society. Another directive is dealing with rental and lending rights, tries to harmonize the legal situation in this area. And when we speak about rental, we are speaking about making available for use of copies for a limited period of time for direct or indirect economic or commercial advantage. And when we speak about lending, we are speaking about making available copies for use, but not for direct or indirect economic or commercial advantage, when these copies are made in establishments which are accessible to the public. So, for example, public lending of books which are accessible in public libraries. Another important directive is dealing with protection, with legal protection of databases. And here, legal protection has 2 aspects. Directive foresees copyright protection and also sui generis protection, which is granted for substantial investment in obtaining, verifying, and presenting the contents of the database. So copyright protection would be applicable for a database if the selection or arrangement of the contents of the database constitutes intellectual creation, and there are certain economic rights involved, as well as exceptions. And in the case of sui generis protection, the directive lays down rules preventing unauthorized extraction or reuse of such content. And sui generis protection is granted for a period of 15 years. And one more, the directive which is related to the so-called first generation would be the term protection directive, which establishes the general term of protection for copyright at EU level, which is for copyright set at 70 years as a general rule from the death of the author or the death of the last surviving author. And this directive was amended in 2011 by extending the length of protection for music recordings. And therefore, it extended the rights of performers and phonogram producers of music recordings from 50 to 70 years. As a general rule, the term of protection of related rights in the EU for film producers and for broadcasting organizations is 50 years. So this was the general overview of the first directives, and then we have, I would say, most important directive in the EU, which establishes a horizontal approach, and it is a directive on the harmonization of certain aspects of copyright and related rights in the information society, so-called information society, or InfoSoc directive from 2001. This directive is important because it implements two WIPO copyright treaties, but also it brought a change because it adopted a horizontal approach. And in case there is a contradiction, and there is no specific rule foreseen, then InfoSoc directive takes priority, and InfoSoc directive applies in case of dispute. So what does this directive foresee? This directive harmonizes main economic rights at EU level, so mainly reproduction right, right of communication to the public, and the distribution right. And to lesser degree, it harmonizes exceptions and limitations to these rights. Directive sets exhaustive list of exceptions and limitations, but there is only one mandatory exception for the right of reproduction for certain temporary acts, which is mandatory. And all other exceptions and limitations, they are of optional nature. And for three of those exceptions, mainly for reprographic works, reprography, private use, and for broadcast made by social institutions, there is fair compensation foreseen, which should be paid for the right holders. Also, it is important to note that Information Society Directive provides legal protection of technical protection measures, as well as protection of rights management information. I will not go into further details, but if in case there are further questions, it can be discussed during the question and answer session. Another horizontal legal act adopted in 2004 is Enforcement Directive, which harmonizes horizontally procedures and remedies in case of infringement. And this directive is applicable to all IP rights. Again, tomorrow there will be another session dedicated to enforcement aspects, and I will be touching on Enforcement Directive when I will be speaking on intermediary liability aspects. So with this horizontal harmonization, well, it was just a second step in harmonization efforts. And then came up approximation of EU laws focused on specific issues. And here we have three more directives. The first one dealing with resale rights, And this directive aims to introduce compulsory resale right for the benefit of authors of original works. And this directive provides that the resale right is normally payable by the seller. It stipulates the calculation of resale price and main beneficiaries of such right. So it is very specific directive. Another specific directive dealing with digitization of works held in the collections of cultural heritage institutions is the so-called orphan works directive. When we speak about orphan works, we speak about works which are protected by copyright, for which right holder cannot be identified or located. And many such type of works are held in the collections of cultural heritage institutions. And the directive foresees that such works can be digitized after completing a diligent search, trying to identify or locate relevant right holders of these works. These works, in order to be digitized, need to be first published or first broadcast in EU member states, and the directive covers various categories of works, not only published books, newspapers, magazines, but also cinematographic and audiovisual works. It is interesting to note that once orphan work is declared as orphan in one EU member state, then it can be considered as orphan in all EU member states. So there is a pan-European approach to that. And right holders, they also have possibility to put an end to orphan work status when they don't want their works to be digitized. And in such case, right holders are entitled to fair compensation. Also, it can be mentioned that there is a single European database collecting all information about orphan works, and this database is set up and managed by the European Union Intellectual Property Office. One more final directive is dealing with collective rights management issues, but I will not go into this directive as there will be a separate presentation on this topic. Therefore, with directives, the field of copyright has been harmonized, I would say, to a large part at European level. However, partial harmonization remains. So, as a general rule, it can be said that copyright in the EU is territorial and respecting legal traditions. Some key concepts have been harmonized, and convergence of national laws can be observed, but different interpretations exist in various member states. And there are still several important aspects in copyright which have not been harmonized at all at EU level. One of those aspects which is not harmonized in the legal acts is the concept of originality. But I will speak about it later today, and I will present some case law from the Court of Justice, where the court basically sets out the standard for originality concept in EU law. Also, another aspect, very important aspect, which has not been harmonized at all, is authorship and works made in the course of employment. Strong differences remain in various member states how these works are treated. Another aspect which has not been harmonized at all is, for example, moral rights. And in some member states, moral rights go beyond minimum requirements. For example, such moral rights cannot be waived or cannot be assigned. Also, important divergences exist in the field of copyright contracts, where different national rules apply as well. And this partial harmonization is mainly due to different legal traditions in different EU member states. And it can be argued today that there are more common features in European copyright law than differences. However, these common principles, they still do not constitute real European copyright law. And most challenging task is to align these different national systems. So the challenge today is not only technological development, but also different legal systems, different legal traditions, but also the debate, public debate, which is often focusing on public's claim to free access to information and sometimes rights to consumers and such things. So I think with this general overview of harmonization, I will finalize my first part. I would be happy to take any questions afterwards. And now I would like to move to another aspect. As you probably know, in recent years, copyright was high on political agenda in the EU, as there was ongoing copyright reform launched by the European Commission. And why this copyright reform was required? Well, it was considered that copyright modernization is needed at this stage of time. And there were three main reasons for that copyright modernization. The first main reason was to provide access to content online and across borders. The second key aspect was to modernize copyright exceptions and limitations, which were quite outdated, considering that the Information Society Directive was adopted in 2001. And then there was another rule and purpose to provide new rules for better functioning on copyright marketplace. And here we see new rules related to operation of online platforms and intermediaries. So as a result of this modernization, we have new regulations and new directives which were recently adopted. First was so-called portability regulation, which is dealing with cross-border portability of online content services in the internal market. And the main purpose of this regulation is to allow consumers to access online content services when they are traveling in the EU. For example, when they are temporarily staying in another EU country, they can access the service they usually watch in their home country, and this could be done without extra cost. So this could be applicable for example, for video on demand services such as Netflix or Amazon Prime, for online TV or online game marketplaces. So there are quite detailed provisions how this is ensured at European level. Another legal acts deal with implementation of the Marrakesh Treaty in the EU. So here we have both directive and regulation. Basically, they set out the rules for how works in accessible formats can be shared between EU and non-EU countries that are party to the Marrakesh Treaty. I will not focus much on these legal acts as well. I would like to speak in more detail on the directive on copyright in the digital single market, which is one of the core directives coming out from this copyright modernization. And this directive addresses the challenges faced by creators and creative industries in the online environment. Currently, the transposition of this directive is ongoing. Legal deadline for transposing the directive into national legislation is June 2021. The directive as such has three main objectives. The first objective would be to adapt certain exceptions and limitations to copyright in the digital and cross-border uses. Secondly, would be to improve licensing practices to ensure wider access to the content. And thirdly, to achieve a well-functioning marketplace for copyright. It is important to know that the directive updates the previous directives, but it does not replace the previous directive. So with respect to first objective, adapting certain key exceptions to copyright, the directive makes it easier to use copyright materials for different purposes, mostly relating to access to knowledge, education, learning. The directive introduces mandatory exceptions to copyright, which are related to text and data mining. So this would be one exception. Then digital uses of works for the purpose of illustration for teaching purposes. And thirdly, exception for the preservation of culture heritage. Also, it facilitates licensing to give access to the content which is held by the cultural heritage institutions. I mentioned the Orphan Works Directive, which is also applicable to cultural heritage institutions. This directive would be dealing with so-called out-of-commerce works, meaning works which are protected by copyright, but these works are not available in commercial channels of commerce. For example, books which are out of print. So the directive sets out specific rules how these works, which are held in the collections of cultural heritage institutions, could be licensed, digitized, and made available to the public. And in this respect, the directive also establishes that a new database needs to be created, which will collect information about out-of-commerce works from all EU member states. And European Union Intellectual Property Office is currently working on the establishment of such new pan-European database for the out-of-commerce works. With respect to providing better access to the content, also the directive provides specific rules on extended collective licensing, and also it sets up a negotiation mechanism to help reach agreements for making available audiovisual works on video on demand platforms. It is also interesting to note that the directive clarifies some provisions related to public domain. So it says that anyone can use and share without restriction works of art which are in the public domain. So this was clear, but now it is specified in the legal act. Also, it sets out a new right for press publications, which is applicable for online users. So there is new right which is granted to European press publishers for the digital use of their press publications. However, these rights are only applicable to users by online service providers and not to individual users. Authors of works included in these press publications should receive appropriate remuneration. Another much debated aspect, which is also foreseen in this directive, is the use of protected content by online content sharing platforms. And the directive stipulates that online content sharing platforms should obtain permissions from right holders to make works uploaded by their users available to the public. And this could be done, for example, through a licensing agreement. And in case the license is not concluded, then platforms can benefit from liability mitigation mechanism, but they must make best efforts to ensure that authorized content is not available on their platforms. Therefore, users are allowed to post content for specific purposes, exploitation, criticism, review, and they also may use complaint and redress mechanisms to cover disputes when works are being removed by mistake by the platforms. So there is a whole new mechanism dealing with these aspects. It is also important to note that there are a number of provisions dealing with fair remuneration for authors and performers in new directive, strengthens the rights of authors and performers when they transfer or license their rights for exploitation. There are new rules on transparency and revocation of their rights in case their works or performances are not being used. So there are important provisions in that regard. And I think I've covered the copyright directive to a large degree, but I know this is new and interesting instrument, and I'm happy to discuss it further. And the final directive, which I would like briefly to touch, is the Directive on Television and Radio Programs, which aims to improve, again, cross-border availability of television and radio programs in the EU by making it easier to clear rights for certain online services. Here we are focusing again on online services or broadcasters. In particular, it is applicable to simultaneous transmissions over the internet, the so-called simulcasting, and to catch-up services provided by the broadcasting organizations. It establishes very specific rules. Again, I will not go into very detail on this with respect to cable retransmission. Again, mandatory collective management is foreseen. So basically, it supplements the previous directive on cable retransmission and satellite broadcasting. As I mentioned, there were three main goals with this copyright reform. And the first goal was to provide wider access to content online and across borders. So this goal, we will see how it works in practice once the directive is implemented and regulations are implemented. But basically, it provides cross-border portability of paid online content services across EU member states when Europeans are traveling. It also hopefully will provide wider distribution of radio and TV programs in EU member states. It will also provide increased online availability of cultural heritage content and of audiovisual works, and it will also increase availability of books in accessible formats. With respect to second goal, to provide new mandatory exceptions in key areas, it will improve the use of copyright protected works in research and innovation by providing an exception for text and data mining. It will make it easier to illustrate digital uses for teaching purposes, and it will also provide possibility for cultural heritage institutions to make copies for preservation purposes, and also to use so-called out-of-commerce works for digitization purposes. It also deals with disabilities, making accessible copies for visually impaired to ensure new rules for a well-functioning copyright marketplace. It establishes new neighboring rights for press publishers, as well as new rules on the use of protected content for content sharing service providers, and, as I mentioned, remuneration of authors and performers. So this was my summary on the new modernized rules in the area of copyright. And now I would like to dedicate the remaining of my time for the practice of the Court of Justice of the EU. Well, the Court of Justice has always had a very significant role to play with regard to European copyright law. And the national courts, they have a possibility to file preliminary references to the Court of Justice, European Court of Justice, whenever they have any question which is coming from the European legislation, when they don't know how to interpret European legislation. And the Court of Justice is in certain sense better equipped to deal with such type of questions because it adopts decisions faster than policy legislator. And this way, it is able to deal with fast changing technologies. So the Court of Justice has been strongly involved in many of the latest developments and interpretations of key concepts in European copyright law, such as linking, framing, in particular, right of communication. And it is important to note that the interpretation from the Court of Justice, European Court of Justice, is mandatory. So member states have obligation to follow the interpretation from the European Court of Justice. Of course, it is not possible to provide very detailed overview of all or many cases coming from the Court of Justice because there is such big variety. So I picked case law on specific subjects, namely on EU originality. Then I will present some cases dealing with exclusive rights and mainly with the right of communication to the public. And finally, some case law dealing with exceptions and limitations and with definition of threshold for protection in European copyright law. I will start with first decision, which is called Infopack decision, and it's first decision, landmark decision from 2009. And in this case, company Infopack scanned articles from newspapers with a purpose to perform electronic search and to print print short extracts of 11 words. And the whole purpose of this process was to ease search and to be able to find relevant articles quickly. So National Court asked Court of Justice whether these acts of reproduction of 11 words are protected by exclusive copyright, or could it be considered as an exception, as an act of temporary and transient reproduction. And the Court of Justice to that question answered that the data capture process of 11 words can constitute partial reproduction that is protected by copyright and related rights, provided that these 11 words in themselves are original and that they are the product of author's own intellectual creation. Therefore, in this judgment, the Court of Justice established the concept of originality, mainly that the work applies to subject matter, which is original in the sense that it is author's own intellectual creation, and it can be applicable to parts of a work, such as in this case, it was 11 consecutive words. And since this judgment, there has been a harmonized EU standard on EU originality that is generally applicable. In further cases, the court has elaborated on this notion of author's own intellectual creation. For example, another decision was dealing with the originality of portrait photographs. I will not present the facts of this case, but just to mention that in this case, the court said that a portrait photograph of a girl was, by creating a portrait photograph of a girl, the photographer was indeed able to make free and creative choices. Therefore, such photographic work can be indeed protected by copyright if it is the intellectual creation of the author. So we see that originality test is moving towards an expression of creativity concept. Next, I would like to move to the case law, which is related to the scope of exclusive rights. And in this area, there is a growing number of decisions in response to the questions referred by the national courts on the concept and the delimitation on the right of communication to the public. I took as landmark decision one of the first decisions from 2006, and since this decision, I think over 20 decisions have been rendered by the Court of Justice. And sometimes from interpretation of the Court of Justice, we see that this right of communication is quite cumbersome and ambiguous concept. It is important to know that EU law does not define the concept of communication to the public. Therefore, it is up to the court to interpret based on specific legal facts of each case. But basically, there are two key requirements provided in the Information Society Directive, which are one of them is communication, and another requirement is that this communication should be directed to a public, and in particular to a new public, which will be explained in further cases that I'm going to refer. So as a clear example of this situation is the broadcasting of works in public places, which happened in this case, Sgaia case against Rafael Hotels, where the court was asked whether the broadcasting in hotel rooms can be considered as a communication to the public. And the court in that case said that placing of television sets in the rooms of a hotel room indeed constituted an act of communication to the public, since the communication did not take place in a strictly domestic location. And the court said that the technique used to transmit it was irrespective in this case. Also, the court said that it is important to know that in the hotel rooms, customers change quickly. However, there was a subsequent case in this area 6 years later, Del Corso case, where the court had to deal with another situation, namely communication to the public in the dentist place, where the court came to different conclusion where they said that the concept of communication to the public is not granted to broadcasting in places where phonograms are transmitted in dental practices. And the main reason was that in these cases, the public of dental practice would be comprised of smaller group of people who were not clearly there to listen to music, but to receive a medical service. So we see that sometimes the Court of Justice is coming to different conclusions. And there were other cases which were dealing with communication to the public in spa establishments and also in rehabilitation centers, where the Court of Justice also said that there was indeed a communication to the public in such places. The main idea to take from these judgments is that the right of communication to the public must be understood in broad sense. This right of communication possesses a catch-all nature, and it should be interpreted broadly. And this was also confirmed in another decision from 2011, which was dealing with broadcasting, ITV broadcasting decision. It was about TV Catch-Up, which offered internet television broadcasting service. And the main outcome of this case is that the court found when a given work is put to multiple use, each transmission or retransmission of that work is a specific technical means, must as a rule be individually authorized by its author. Therefore, a retransmission of works over internet is aimed at indeterminate number of potential recipients, and it is indeed a communication to the public. What is important to note is the concept of communication to the public does not vary depending on who the right holder is, but the public at which the communication is directed refers to unspecified number of potential recipients, and it is very important that this public must be new. And this case of new public was dealt in another decision, which is a very famous decision. It's called Svensson case, and in that case, the court interpreted mainly this question of new public. And it said that basically it dealt with clickable links. It dealt with Swedish company which operated a website through which users received hyperlinks to articles on other websites. And these hyperlinks were provided without the permission of respective authors. So the authors claimed, and the court said that the provision of hyperlinks to copyright protected content does constitute an act of communication to the public. However, the court was asking, is it really a new public? Because the technology used was the same. So in order for communication to the public to take place, there must be a new public. And it means public which was not taken into account originally by the copyright holder, when the copyright holder granted authorization to use their rights. And the court said that in this case, there was no restriction from right holder. For example, there was no paywalls. Accordingly, the links did not make the articles available to a new public. There was no requirement to obtain authorization from the right holder. Another case dealt with a question whether a website operator who embeds copyright protected works in videos using the framing technology communicates the works to the public. And in this case, the court said that embedding a copyright protected work on a website using framing technology cannot be considered communication to the public as long as the protected work is not communicated to a new public by technical means that would be different from the means of the initial communication. There are different technologies that the Court of Justice has dealt with. In another case, the court shed some light on the question whether and under what conditions hyperlinking to works which have been made available on the internet without right holders authorization, this is important, constitute an act of communication to the public. And here the court referred to the full knowledge criteria. The court said that where the person acts in full knowledge of the fact that the work has been uploaded without right holder's consent, such hyperlinking indeed constitutes communication to the public. And when such hyperlinks are posted for profit, such communication should be presumed. One more case was dealing with the lawfulness of the sale of multimedia player, which enabled access to infringing material. And in this case, the court also said that the sale of multimedia player with pre-installed ads available on the internet containing hyperlinks to freely available content does indeed constitute an act of communication to the public. Last case which I would like to touch in this area no, I have one more case, but maybe I'll shorten. There's one more case about cloud services, which I'll skip. So just briefly, in the case of cloud services, the court also said that there was indeed communication to the public. There is one recent case which is quite interesting, and it deals with reposting of a work, which is freely available on a website. The court was asked whether it amounts to an infringement. So here, a photographer authorized online travel portal to use his photography, and this photographic work was taken by a student and used to illustrate school paper, and later this school paper was made available on school's website. So in this case, the court said that reposting a protected photographic work that was made available with the right holder's consent and without any technical constrictions can infringe indeed copyright, because there is new public involved by downloading a work from one site and making it available on another website. So as we can see, reposting is different from hyperlinking. And then I would like to go to the final part of aspect related to sampling. The court was asked whether sampling infringes copyright related rights. So here the court had to deal with the use of very short sequence of a phonogram, a sample, which was used in another phonogram. It was approximately 2 seconds of the rhythmic sequence which was used, and according to the Court of Justice, sampling amounts to reproduction in part in the sense of EU law. However, using a sample in a modified form, which is unrecognizable to the ear, would not infringe the phonogram producer's exclusive rights. One more important aspect which Court of Justice stated in this case is that EU member states cannot provide other exceptions than those that are provided in EU legislation. Therefore, there is limited freedom for EU member states to legislate on new exceptions. I have one more case on exhaustion of rights, which is dealing with lending on digital copies in libraries, where the court mainly recognized that exhaustion principle applies to lending of digital copies, but during the lending period, only one copy may be downloaded, and after the lending period has expired, the user cannot use the downloaded copy anymore. And I would like to finalize with my presentation with one case dealing with what could and what could not be protected as copyright protected work under EU copyright law. And in this case, Lavola case, the court explained that the taste of the food product could not be protected by copyright under EU law. And the court argued that a work under EU law should consist in subject matter that is original in the sense that it is author's own intellectual creation, which we heard already from previous law, and only expressions of author's own intellectual creation may be classified as works. And what is important is that this work must be expressed in a manner which makes it identifiable with precision and objectivity, and this condition cannot be fulfilled for taste products. So it would be impossible to identify food product with sufficient precision and objectivity. Therefore, a food product could not be protected by EU copyright law. Of course, there are many interesting cases, and this is an area which is developing very fast. So I would like to finalize my presentation and leave more time for questions and answers. Thank you very much for listening.